I'm never just going to give you something if I don't agree with what that is. That's not how we do things. So if that helps with that understanding, I'm gonna let you visit with Mr. Lewis again, and go over that. But it's definitely I don't do that. I never have, and I never would do that. I don't think that's actually the right way to do it. So you're pleading guilty based on an agreement. And so if you don't take that agreement, or if I don't take that agreement, we'll start all over. Okay? All right, y'all go back and visit. And so, Mr. Smith, before you came out, Mr. Lewis explained that some of the hesitation you have, that there's an agreement that you guys have worked out that you're willing to accept, but you're a little concerned because Harris County does things differently, I think, than we do. I just want to let you know how we do things. And then if you want to enter that plea, you can. If you want to go to trial, you can do that. Okay. What I do is if someone pleads to an agreed plea, I do take that plea today, and then I reset your case for sentencing. During that time period, I have the probation do a pre-sentence report just so that I have more information when we come back. If for any reason at that time, there's something in that pre-sentence report that makes me say, you know what, I'm not going to follow this agreement. And what I do is allow you to withdraw your plea of guilty. And then we start all over. You go to trial or y'all work something else out. Again, you're Joshua Smith.
Yes.
And Mr. Lewis, will your client waive more reading of the indictment?
You do.
Mr. Smith, in cause number 25, DCCR 1439, you're charged with the first degree felony offense of fraudulent use or possession of identifying information in the amount of 50 or more from August 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that PSI done, and then we'll come back later for sentencing. Mr. Smith, what is your position with regard to bond based on that?
We're not opposed to a PSI bond on this, Judge. I believe there's a little bit of criminal history, but I think it'll be fine on this case.
So, Mr. Smith, what I'm going to do in your case is, based on the nature of your plea, is reduce your bond to $1,000. If you're able to make that bond, there's a couple of very important things about it, though. The first thing you do when you're released from custody, if you make that bond, is go to the probation department so you can get that pre-sentence report and started. You're going to get some information today, some paperwork, so that you'll know where to go. Also, if you bond, don't do that. If you don't show up, don't get that report done, you run the risk of me not accepting the plea agreement. If you're arrested for anything between now and when you come back, you obviously run the risk of me not accepting the plea agreement. And there's no, I was going to ask this a minute ago, there was no restitution or anything like that. All right, so you'll get some paperwork from probation this morning. If you make the bond, do everything you're supposed to. If for some reason you don't, they'll come out to the jail and do that pre-sentence report out there. Okay, see y'all back at sentencing.
Thank you.
No.
Yes, Your Honor.
Morning.
Morning.
Good morning.
Good morning, sir. Are you David Boyd?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Let me get it pulled up the right way real quick.
Judge, what we're doing is pleading him to it's the same offense, deadly conduct, just under 22.05A, which makes it a Class A misdemeanor.
05. All right. Mr. Boyd, in cause number 25, DCCR 0720, The state has elected to proceed on the lesser included offense of a Class A misdemeanor of deadly conduct, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Boyd is not competent?
No.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have the conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's sitting at that desk right over there. She's going to call you up to her desk to go over all of your paperwork when she's ready. All right, good luck to you, sir. Thank y'all for working this out.
Thank you,
Thank you.
Judge.
It's
Thank you.
Yes, sir.
going to be hard to get through a bunch of words.
Now
It's going to be hard.
Now I get to go and use the teacher.
Have fun. Harold Denton. Yeah, how are you? Yes. Have you ever been on treatment? Good morning. Good morning.
Sure, how many count you want him to plead to on that? There's an agreement for 7 years TDC.
Okay, I'll take a look at the,
I'll waive any of them that you don't deem necessary.
hey, sir, are you Harold Denton?
Yes, ma'am. How are you?
Good, thank you. And, Mr. Lewis, will your client waive the formal reading of the motion?
You do it, Judge.
Mr. Denton, in cause number 21-37744, I have a motion to revoke the community supervision. Shows that you were placed on probation October 20th of 2021 for the offense of assault on a peace officer, a 2nd-degree felony, and that was a 10-year prison sentence that was probated for 10 years. Is that correct? This motion alleges that you violated your probation. It alleges in count 1 that you failed to report to the probation office as ordered September 26th, October 17th, November 13th, and December 1st of 2025. And is that true or not true?
True, Your Honor.
Count 2 alleges that you failed to immediately report your home address and phone number also to the probation office as required. Is that true or not true?
It's true, Your Honor.
Count 4 alleges, I'm going to dismiss 3. Count 4 alleges that you failed to be placed on the mental health initiative caseload as ordered due to the fact that you absconded and you were unavailable for placement. Is that true or not true?
Yes, ma'am. That's true. I had
Count.
difficulties.
I'm sorry.
I had some difficulties. They stole my medications from my backpack at the bus stop, and I just
Okay. Count 5 alleges that you failed to successfully complete the BIP program. Is that true or not true?
The what program?
BIP, the battering intervention and
This is true. Yes.
okay. Think with the agreement, if y'all are okay, that's fine.
9 was the failure to complete.
There we go. 9, count 9 alleges that you failed to enter and successfully complete the Safe P outpatient aftercare. Is that true or not true?
Aftercare is from I successfully completed this. The
Right.
analysis.
This is just the aftercare. You got to do the whole thing.
Yes, ma'am.
All right. Did you enter your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily?
True. Right.
And did you plead true to those counts that you pled true to freely and voluntarily?
Yes.
Okay. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Denton is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke the probation. Reassess your punishment in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Yeah, he was, I think, on strike probation. He definitely beat that.
Well, his was in 21, and I think we started, I think it was 22 or 3 when I started reading it. So in my mind, if it was 22 or before, because I can't remember, I just do it again.
Yeah,
I can't remember the exact day. I know. And I need to say so many more words today.
that's what I was waiting. Felt like we only had you for a little bit this morning.
Yeah, luckily it's not a big day. Let's see. Perry Heard. Good morning. Are you Perry Heard Jr.? I'm sorry.
Right.
Okay. And this is cause number 26 DCCR 0052. Mr. Heard is charged with harassment of a public servant. I'm going to take judicial notice of the court's file. I received a report from Dr. Capon with regard to competency, and that report is dated June 23rd of 2026. The finding in the report is that Mr. Heard is competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, not from the state.
Right, that at this time, based on that report, I am going to find that Mr. Heard is competent to stand trial. And what is the announcement?
Judge, I have received a new offer this morning since visiting with Mr. Hurt in regards to his offense, Judge, and I think it's something that could possibly resolve this issue. If I can just get a short reset in so I can explain that and go over
Sure.
with Mr. Hurt.
You want a week or 2?
About 2 weeks.
Okay, we'll reset the case 2 weeks, Mr. Heard. Mr. Lewis will be out there to go out and visit with you about all your options, and we'll get an announcement at the next court date.
This is the court date for today, right?
I'm sorry,
So this is my court date.
today's your court date, but I'm gonna move it for 2 weeks so that Mr. Lewis can spend some more time with you going over everything, okay?
All right, so I've been in there and I'm enough to Let's see if I need time served or how.
Talk to Mr. Lewis about all your options and he'll let you know what they are, okay?
Okay.
All right, he'll be out there to go over all of it and make sure.
Looking good for him.
He'll be out there to go over all that, okay? You can go back with the bailiff.
I'm gonna talk to y'all whenever.
All right.
No problem.
Denisha McMillan.
Yes.
Morning, ma'am. Are you Denisha McMillan?
Yes, ma'am.
And this is cause number 26, DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with the third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am. I'm just ready to do my time.
Now, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing, before you go any further, when you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial. But I'm not going to allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, then I'll ask the same questions again, but that's going to be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes, ma'am.
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All
ma'am.
right, you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's, I mean, we'll see what the other attorney does, but I don't intend to keep that deal. I'm sure you don't either.
No.
All right, Kadesha Scott. Morning, ma'am. Are you Kadesha Scott?
Yes, ma'am.
And this is 26 DCCR 0797. Ms. Scott is charged with the first degree felony offense of aggravated robbery from July 3rd of 2025. And what is the announcement?
Judge, in this situation, we have the complaining witness who's evidently been trying to get in touch with the state
Okay.
in regards with this issue. And actually, I talked to the complainant myself a few times where they've called me saying they've called trying to get in touch with the office. I've given them their number up there so he can get that taken care of. That's the main weight that we
Okay.
have on our end.
Sure.
And Judge, I mean, in the meantime of that, of course, I would like to possibly either, I know we may not be able to take care of it this morning, but at least get a bond hearing set for Ms. Scott until we can get that worked out.
Let's do this. I mean, is there any reason you can't try to get that worked out this week to get in touch with him?
This is a case I inherited from Mr. Coleman.
Okay,
The number that Mr. Lewis has for him is the number that we have in the file. We did send him a letter. Tommy sent a different letter than we normally send, and it was returned. So I don't know about the address, but the phone number apparently is good. I didn't have a message that he had called, but I will reach out to him.
okay. Let's do this. I'm gonna reset it 2 weeks, and that'll give Mr. Smith time to kind of get caught up, make that phone call, get in touch with them. If by that time, between now and then, if you want to go ahead and file a motion for bond reduction, that way everybody's on notice and we could have that hearing on that date if something else doesn't get taken care of.
Good.
Okay, all right. See you back in 2 weeks. Joshua Smith.
Speak to somebody from.
Yeah, the held him for us.
Now in the original, I mean, in the new
I can
case?
ask him to either redo it or I can, yes, ma'am, I can get it in there.
Okay,
I will do that.
okay, let's see. You are Gabrielle Smith? Stand up, please. And this is cause number 25 DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct? Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the other one? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now before trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
And guess what? Just here. Ready to give my charges, I guess, decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Two, three, yeah, but 2,3 D, or 1030.
Like, such a big copy of the middle box.
Every time something anything.
So it looks like okay, there was back in February of 2024, there was a bond forfeiture. So the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She then entered a plea, Your Honor. PSI bond.
I did
That
at
plea was
one.
Rejected by the court.
Okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess.
for a PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out.
What goodness. Sufficient.
Okay. And then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000. So I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report.
Revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you were rejecting that.
Right. And several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at $40,000 on a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. Involved a vehicle. I think the officer had leaned into it and then the vehicle went into motion. And,
Well, how did the vehicle go into motion?
well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
She scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about in the vehicle, I suppose.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got a speedy trial, I guess, so we need to try.
In the 252nd, everything's speedy.
All right.
It will be placed, I mean, is it? It wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
Well,
the,
I guess if this court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
Take 8. Take 8. You want me to do a rejection?
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Goodness gracious. Mr. Matusko, you've got Xavier Garner. 6 cases. Oh, I don't have, hold on, let me recall that in just a second. Do you have some stuff coming through on Garner? I've got a registration, but I don't have anything else. All right.
And then I'll need to take out of the computer.
Okay, that's okay. I'll hold it for just a second. Thank you. That's gonna be a good one. Get rid of 6 pages. Mr. Parker, you've got Jacoby Judge.
Can't remember what I've done on
I know, I just looked up and I've got a line of things ready, which is good. Yeah. Good morning. Are you Jacoby Judge?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Judge, in cause number 24, DCCR 1174, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 17th of 2024 for the offense of obstruction or retaliation, a third-degree felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to provide verification of attending the SafeP program. Is that true or not true?
True.
And then count 2 alleges that you failed to successfully complete the SafeP program. Good grief. These are a mess.
I don't know why they phrase them like that, Judge. I mean,
All right.
he did it twice.
Okay.
But
You didn't complete the SafeP program, right?
no.
Okay. Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And because those counts are actually true.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Judge is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
It's on there. It's not real now.
Warren Mills.
Judge, I'm
Mr.
going to ask, we reset that a couple weeks. We've had an issue with the video. I've got the video and I need to go over with him. He wants to talk to his
Okay.
family.
All right. We'll just do maybe about 3 weeks on
That's
Mills.
Third Street, I believe.
Shaniqua Washington.
Third Street.
Morning. Good morning. Are you Shaniqua Washington?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Washington, in cause number 24, DCCR 2370, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from September 29th of 2024. The indictment alleges you were previously convicted of theft April 7th of 2010, and then again July 12th of 2012. And how do you plead to that charge? And are those two prior convictions true? Did you enter your plea of guilty freely and voluntarily? And because you actually did what they charged you with? Did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a deferred probation. How long?
3 years.
I'm sorry. Can y'all, any problem with me writing that in?
I wrote it. Well, maybe
didn't-
she
it
probably
didn't come
sent it.
through.
She sent it before.
3 years. Okay, so a 3-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Is there any restitution, or were the items
They were recovered.
recovered? Okay. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Washington's not competent?
Very right.
Other than those 2 that are listed, do you see other issues? or-
I see nothing but misdemeanors, so she's got misdemeanor history.
Okay,
We're asking waive the DSI.
We're okay with waiving it, or if the court wants one, we're okay with it. We are on.
yeah, I mean, if yours,
There is
This-
history.
there is, I mean, the last one that's listed here is 2012,
We've got some other charges other than.
That's misdemeanor.
other than thefts. Okay, all right, then I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Did I print that? Do I need to do it again? I might not have. Okay, going to find sufficient evidence to find that you enter your plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. That shows this was an agreement that I followed, so you waived your right to appeal. Probation's going to talk to you before you leave today. It's very important that as soon as you get out, you do everything that they're tell you to do, okay? All right, good luck to you, ma'am. Let's see, Kendrick Williams, 4 cases are called, Mr. Parker.
Kendrick Williams.
Your papers are gonna be on there, but we're on this day, just say more of it, you don't know, we're working on it right now.
Okay, so we've
I
got,
didn't write CC on these cases, Judge, but
okay. That's fine. And are we going on, are there more than one count? Are we going on?
On the
I
motion,
did
Your Honor?
second degree.
No, are they all,
Well, the
new
state jail
cases.
that's enhanced and
The state jail requires its enhancements.
that's the possession?
Yes,
I-
sir. Well, there's 2
I'm-
possessions, Your Honor.
I'm thinking about it.
No, the evading arrest for previous convictions.
I'm just now thinking I may have filled out the state jail paperwork wrong. I'm not positive, but I may have.
Just be patient with me as I pull it and then I'll figure out what we need to do, if anything. Okay. Are you Kendrick Williams?
Yes, ma'am.
And will your client waive the formal reading of the indictments and also the motion?
He will, Your Honor.
Okay, so there are priors listed, so it is count one. I'm assuming,
Yes, Your Honor.
at least on the 1075.
But it's not needed. 1075 or 2352.
Okay, just 1076 today.
Yes, Your Honor.
Okay. In cause number 24, DCCR 1075, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of possession of a controlled substance from February 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? Give me just a second. In cause number 24, DCCR 1076, you're charged with a state jail felony offense of evading arrest or detention with previous convictions. And is he getting state jail time on
No,
this?
that's what I think. I
So we
filled it.
need all of them.
Yes.
Did you do state jail paperwork?
I don't remember. I'm thinking I've had in state jail paperwork. I've got this one up here. I've redone it. I just don't remember if I did or not.
Okay. So the offense date on this is from February 19th of 2024. The indictment alleges you were previously convicted of evading arrest or detention September 26th of 2007. It further alleges that you were previously convicted of possession of a controlled substance, a state jail felony, September 24th of 2007, and also possession of a controlled substance, a state jail felony, September 4th of 2012. And how do you plead to that charge? And are all of those prior offenses convictions true?
Yes, ma'am.
Okay, let me make that note real quick. This is so much better than paper. Okay, and then in cause number 24, DCCR 2352, you're charged with the second-degree felony offense of injury to a child, elderly, or disabled individual from July 19th of 2024. So that's already a second. Are we going on the other counts as well,
We
or
don't
no?
need to, Your Honor, just count one.
So in that count one only, how do you plead to that charge?
Yes, ma'am.
And again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In all three of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes,
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes, ma'am.
State tenders number 1 in those 3 cases.
No objection, Judge.
It's admitted in each of those cases. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in cause number 24 DCCR 1075, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You did it right.
I did? Okay.
In cause number 24, DCCR 1076, I'm also going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And in that case, find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2352, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now let me get the MTRP pulled up.
And Judge, counts 1 and 2 include some of the cases we just pled to. The third one was not yet added as amendment, but since we had an agreement, we'll just go on 1 and 2.
1 and 2, okay. All right, in cause number 21, 36841, I have a motion to revoke your community supervision. It shows that you were placed on probation October 13th of 2021 for the offense of assault on a peace officer. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense that we've already talked about of evading arrest or detention with previous convictions, February 19th of 2024. And is that true or not true?
Yes, ma'am. Sure.
And then count 2 alleges that you committed the offense of possession of a controlled substance, February 19th of 2024. And is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I'll also have here on the computer in that case some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these papers with Mr. Parker?
Yes, ma'am.
And do you fully understand them also? And you understand if I follow this agreement, you will be waiving your right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all. What you need? Y'all need some? Yeah, I can do this. Give me this.
Yeah, you don't, new cases,
Okay. Bailiffs already know. Okay.
Damn.
It's reset up here. Just.
Amanda Arendt.
Judge, we're gonna, that's, the state is asking that we reset that. It's Ms. Malfino's case. She's trying to talk to somebody about, I don't know, to give me an offer.
Okay,
She's asked us to reset.
we'll just do one normal reset on that. Kyla Allen, it's a sentencing, Mr. Parker.
Yes, Your Honor. No, she can go back. I told you already. Kyla Allen. For sure. So, oh, you gotta get their level of argument.
All right, ma'am, are you Kyla Allen?
Yes, ma'am.
And this is 23 DCCR 0639. Ms. Allen was placed on probation October of 2023 for evading arrest or detention with the use of a vehicle. In court, previously entered pleas of true and a motion to revoke probation to counts 1 through 10. I've received that updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections to that report?
No, Judge.
Not from the state, Judge.
And this is unagreed. Mr.
Correct.
Parker, you may proceed.
Your Honor, all I can say is, these violations are all technical, even though, I understand that they're still serious and you have to follow the rules of probation. She's young. She's 19 years old. I think being in jail has opened her eyes, and she wants to complete probation. She has quite a bit of time behind this, and my deal was, take the time. She said, I don't want to do it. And she's sincere. She says, I want to prove to myself and prove to everybody else that I can complete this probation. And she has the opportunity. She has a job waiting for her. She gets out, and she's requesting this probation, and she'd like to address it for the judge.
Go ahead, ma'am.
I just want to say I own up to all my wrongdoings. I do. I know it was wrong. I knew it was wrong when I was doing it, and I regret it. But I want to prove that I can do better, and I'm not the person that I got to be. I'm young. I want to build my relationship back up with my people, make it stronger, build my trust. Just do the right thing. Make it right before it's too late.
Thank you, ma'am. Mr. Coleman?
Your Honor, this is Mr. Smith's case. I'm under the understanding that Mr. Smith made a 3-year offer in this case. I am cognizant of the fact that recommendations from probation department on the last page states that while the defendant's violations are mainly technical in nature, this officer is not inclined to recommend continuation of supervision at this time. So with that, my position is the same as Mr. Smith's, that should be revoked.
And that's where this courtroom moment comes to an end. The judge made the consequences crystal clear, and now the real responsibility falls on the defendant to make better choices moving forward. What do you think about the judge's decision? Let us know in the comments, and don't forget to like, subscribe to Final Word, and watch the full video for more intense courtroom moments.